My name is Jeff Morgan. I am from Dallas, Texas, and currently I'm at the Rockwall Courthouse in Rockwall, Texas. So one of the things I wanted to talk about was the Supreme Court case that we were very much involved with, and this was the case of Ryan Pankoe, the petitioner, versus Laura Pankoe. And this was in the United States Supreme Court, the Supreme Court of the United States. And we actually, Brian is a friend of mine. We've been working on this case for several years. When I say we've been working on it, I wasn't the one who primarily authored this. I had some input into it. But Ryan was the one who was fighting the issue, and then another person, Matthew Johnson, was the one who did most of the petition. He was the one who wrote it. And the issue pertained to that of unilateral no-fault divorce. Now, the argument behind this petition was very simple. It was, number one, that with unilateral no-fault divorce, that it is automatically a predetermined outcome of divorce. If one person wants a divorce, that person will get a divorce regardless 100% of the time. All the state does at that point is the state divides things up. Divides up children as far as which parent they're going to live with, divides up assets. Maybe you have to sell a house or a car or something to pay for your spouse's attorney fees, or impose upon you other obligations such as the issue of alimony, or spousal support, or child support. And this is very unfair in many instances because the person who actually has this imposed upon him or her is the person who wanted to keep the family together. Now this case was being argued on the basis of the First Amendment, on the Establishment Clause. The Establishment Clause being that the state of Pennsylvania always, without exception, would take the position of the person who wanted the divorce, the petitioner. Even though no fault was involved, even though there was no legal transgression that was involved, even as the testimony said that there was nothing that he did, the state dissolved his marriage because one person wanted it dissolved. The state took away children from him, gave the children to his wife. The state made him pay child support. The state has plundered this man for no reason, simply because the wife asserted her viewpoint was that the marriage was irreconcilable and irretrievable. Now, Mr. Pankoe did not believe that. This was a case, though, that the state always, the state of Pennsylvania, would always take the side of the petitioner. And we actually have this very same thing in the state of Texas. The petitioner always, without exception, wins. There is a predetermined outcome. It's interesting to hear some of these family law attorneys talk about going to final trial or something like that. It is a sham trial because the trial would be something that would allow you to prove your innocence, allow you to have a defense. There is never a defense for unilateral no-fault divorce. The whole thing is sham. Basically, if you want to look at the lawsuit, it's my opinion versus her opinion, or it's her opinion versus my opinion, her viewpoint versus my viewpoint. So what is the state really ruling on in such an instance? The state is taking the side of a viewpoint, a belief, and has given that belief the force of law. For the person who petitions for divorce, that state will always, without exception, back that viewpoint. There is no due process, and there is no investigation of the facts. There is nothing that a person can do to stop the divorce from taking place. So what the state is actually doing, that they are establishing a doctrine that is saying whenever somebody files for divorce, that divorce will be granted. It is a predetermined outcome. So this case is being argued on the basis of the Establishment Clause, that the state was establishing a belief, a system, something that was there that the state said, we will side with this belief 100% of the time, which is forbidden by the First Amendment to the United States Constitution. The second thing that was being argued was this, is that Mr. Pankoe actually had no due process protections. Because if you are being taken to court, and divorce is a lawsuit, if you're being taken to court, you should have the ability either to win the lawsuit or to bar the lawsuit. In unilateral no-fault divorce, and I stress unilateral, because unilateral says one person wants it, one person will impose divorce upon another person, and at the same time often will plunder his or her assets, often will seek custody of the children, and they have not made an allegation of any wrongdoing. What this has done, it has removed every legal protection from marriage. In the state of Texas, which I've argued many times, there is no legal protection for the institution of marriage. And you know that because unilateral no-fault divorce exists. For any reason or for no reason, a person can make up a reason, and the state will automatically, through its judges and everything else, grant the dissolution of the marriage. And the family law attorneys who are there to help you often don't disclose the fact that there is nothing you can do. Now, there are some attorneys that are honest. In fact, one of the law firms, Kuntz and Fuller, which I think is a law firm that I do not like. I despise that law firm because of some of the things that I've seen them do. At least they are honest enough. They will tell you that if your spouse is filing for a divorce against you, the only thing you can do is try to convince her or try to convince him not to do it. The divorce will be granted. There are no exceptions. So anyway, there was a statute in the Pennsylvania State Code that we were trying to have declared unconstitutional based on what the Supreme Court said, based on the testimony, the transcript, and everything else. I thought it was a slam dunk case. I thought we would have actually won this case, and this would have had ramifications throughout the entire divorce industry in every single state. Why is that? Because every state basically has a clone of what Pennsylvania has. Every no-fault divorce statute is about the same. It gives the respondent no protection. The respondent, all that he or she can do is say, what kind of division of assets can I get out of this? And often the respondent is victimized by the courts, victimized by the state. Now, in the state of Texas, we actually have in our state constitution, Article 3, Section 5613, the legislature is prohibited from passing any legislation granting divorces, any special laws granting divorces. And yet our Texas legislature has done that. This has been taking place in our state since the 1970s. So we're talking about 45 years. It's been taking place in our state of Texas. And for the most part, most people aren't challenging it. It is unconstitutional as can be. The state legislature has exceeded its authority. And I think it's very interesting because right now the legislature is trying to rein in the governor for overstepping his authority as an executive of the state during the COVID crisis. So they want to rein in the authority of the governor, which actually should be done, but they will not rein in their own authority. The statute in the Texas Family Code is called 6.001. It deals with insupportability. Insupportability is not defined. The whole statute should be voided by vagueness. Not only insupportability, but also the idea of the legitimate ends of the marital relationship. What does that mean? Nobody knows. So here's a statute that should be voided because of vagueness. Nobody knows what it means, but this is the statute that the state of Texas uses to dissolve marriages indiscriminately, giving the respondent absolutely no ability to put up a defense or to stop the lawsuit from taking place. And once again, in most of the instances that I've seen, the respondent gets further penalized by the state. Often the respondent has to pay some type of child support, alimony support, often will not get to see his or her children on a daily basis. The state is involved in the family destruction industry, and that is a shame. Anyway, this is the case that we did have. It was completely disappointing that the Supreme Court did not hear it. I guess maybe we shouldn't have expected them to. But from my perspective, we spent a lot of time and money on this. I know Mr. Pankoe spent a lot of money and heartache researching the law for himself, going through the whole process. I know Mr. Johnson, who actually wrote this stuff, spent years trying to write this stuff up right, finding the arguments that could be phrased in such a way, using the transcript to make the argument solid, invoking case law, looking at constitutional issues. My involvement was not like theirs, but I did finance the case as far as the printing of the stuff goes. 42 copies or 46 copies, I believe, 42 or 46 had to be printed. We went to a Supreme Court printing press in Massachusetts, and they knew how to get everything done because you have to follow a specific protocol in order for the court to even consider it. So that was about $4,000 that we spent. $4,000, and the Supreme Court just said, denied. That's it. That was a disappointment. It is still the most critical issue, I believe, facing the United States of America in every single state. Why? Because the destruction of the marriage leads to the destruction of the family. Vladimir Lenin put it like this: destroy the family, destroy society. He knew that by destroying the family, he could destroy society. It is a big disappointment. I wanted to give people update about that case. It never got heard. For those who want to pursue it, there is a template out there. If anybody does want to try to pursue this either at a state level or at the federal level, as we did in this instance right here, feel free to use the petition as a template and just modify it to your own state. Anyway, I wish I would have had better news to relay regarding that, but that's what it is right now. Thank you so much.